Good afternoon, and welcome to McGuireWoods SEC Compliance and Disclosure Update. I'm Janie Sellers, a partner in the firm's Securities and Capital Markets Department and the moderator for your program today. McGuireWoods is a full-service law firm with more than 1,100 attorneys in 21 worldwide offices. Our more than 50 securities and capital markets lawyers represent some of the nation's largest businesses and financial institutions. We regularly serve as counsel in public and private securities offerings and help clients understand and address unique securities compliance issues and reporting requirements. We were recently named Banking and Finance Law Firm of the Year by Law 360 and consistently rank among top law firms representing clients in capital markets transactions. Before we begin today's program, I'd like to call your attention to the Q&A icon in the lower left-hand corner of your screen. Please use this widget to submit any questions you may have for our panelists at any time during the program. We'll do our best to address your questions in the time allotted. However, since we have a pretty full schedule today, if we're unable to do so, we'll follow up with you by email. You'll also find a number of additional resources across the bottom of your screen, which we encourage you to explore during the presentation. Notably, the meeting materials folder includes a copy of today's presentation slides. So now we'll begin. Allow me to introduce our first speaker, Lisa Taylor. Lisa is based in our Jacksonville office and concentrates her practice on public company reporting and corporate governance matters. She'll be discussing the SEC's proposed rule changes on shareholder proposal submissions. Lisa, it's your turn.
Thanks, Janie. On November 5th, the SEC issued proposed amendments updating the criteria for submitting shareholder proposals. In proposing these changes, the SEC said it considered the following: the staff's extensive experience with shareholder proposals, including the more than 250 no-action letter requests in 2018, the significant changes that had taken place in markets in the decades since these regulatory requirements were last revised, including the extensive amount of shareholder engagement that happens between companies and shareholders, and also the substantial shift into investing through mutual funds and EFTs rather than through Main Street investors. In proposing the changes to the shareholder proposal rules, the SEC was weighing the cost savings to shareholder proponents. They get to save money by including their proposals in management's proxy statement against the costs that it imposes on companies. And these include the cost of preparing no-action letters and the time and attention of management and the board in considering how to respond to these requests. With respect to the requirements regarding shareholder proponents' ownership of the company, the proposed rule changes keep the SEC's $2,000 minimum ownership threshold, but eliminates the rarely used ownership threshold of 1% of outstanding shares. The new rules would require proponents at the $2,000 level to have held the shares for 3 years. That's increased from 1 year. The changes add 2 other levels of ownership. A shareholder that's held $25,000 in value for 1 year or $15,000 for 2 years may now make a proposal. The rule changes do not allow shareholders to aggregate their securities with other shareholders to meet these minimum ownership thresholds. In proposing this change, the SEC noted that the current ownership thresholds that were established over 20 years ago did not appear to strike the appropriate balance when 5 shareholders accounted for 31% of shareholder proposals submitted in 2019. The proposed amendments would also update the single shareholder and shareholder representative rules. The current rules have a one proposal rule that states that each shareholder can only submit a single proposal. The proposed rules would allow each person, including representatives, to submit only one proposal. This means that a person acting on his or her own behalf as a shareholder or as a representative will be limited to one proposal per company per year. In other words, a single person may not submit multiple proposals to the same shareholders meeting on behalf of different shareholders. The proposed rules require documentation about the authority of the shareholder representative. The new rules now require the proposal to identify the shareholder proponent and the designated representative and include the shareholder statement authorizing the designated representative to submit the proposal or otherwise act on the shareholder's behalf. It also includes the shareholder statement supporting the proposal and be signed by the shareholder. The proposed rules would also require a proponent to state that the proponent is available to meet with the company between 10 and 30 days after submitting the proposal. This would include contact information for the shareholder proponent, as well as the business days and specific times that the proponent is available to discuss the proposal with the company. This is intended to encourage greater dialogue between shareholders and companies in the shareholder proposal process and to lead to more efficient and less costly resolution of these matters. The proposed rules would also update for the first time since 1954 the levels of support that a proposal must receive in order to be eligible for resubmission. Under the proposed amendments, the proposal would need to achieve support by the following levels to be eligible for resubmission in the following 3 years. It must receive 5% support in its first submission, 15% support in its second submission, and 25% support in its third submission. The new rules also add a momentum requirement. A company may exclude a proposal previously voted on 3 or more times in the past 5 years, even if it received 25% support on its most recent submission, if the proposal received less than 50% of the votes cast and it experienced a decline in shareholder support of 10% or more compared to the most immediately preceding vote. In changing these support levels for resubmission, the staff noted that it had reviewed shareholder proposals that had ultimately received a majority vote in a second or subsequent submission between years 2011 and 2018. And this SEC review found that of those proposals that ultimately went on to receive majority support, 98% started with support over 5% in the first submission, and of those that received support on their third or later submission, 95% of those received 15% on the second submission, and those received 25% on the third or more. So that's the reason the SEC feels those levels are appropriate. The proposed rules are available at a link, and the comments are due on February 3rd, 2020. Since these aren't final rules, companies should continue to rely on the current shareholder proposal proxy rules for the 2020 proxy season. Also, I wanted to recap a couple of other recent developments on shareholder proposals. As you may recall, in September, the SEC's Division of Corporation Finance announced 2 significant procedural changes for responding to Exchange Act rules. They noted that for this current proxy season, 2019 and 20, the SEC may give oral responses instead of a written response for routine matters. They might provide no definitive response in some cases. They would provide written response letters where it might provide value. In any case, the SEC would still advise each party of its position and noted that, of course, companies can always seek adjudication from the courts. We understand that the SEC plans an informal response system where it will contact both parties to a no-action letter, alerting them by email that a decision will be coming down, and then the SEC website would have a chart that would show the SEC's response. It would be a simple yes or no without explanation, but it would show the various exclusion under 14A8 on which the decision was based. The SEC's website would also include the related correspondence that might happen at a future time. Also, I wanted to note that in October, the SEC released Legal Bulletin 14K on shareholder proposals, and these provide additional guidance on the exclusion 14A87, which is known oftentimes as the ordinary business exception. And this Legal Bulletin gave additional guidance about what board analysis included in the no-action letter request would demonstrate that the policy issue in the proposal wasn't significant to the company, and also talked about how to use the micromanagement basis to exclude a proposal. And lastly, that legal bulletin addressed the handling of a proponent's proof of ownership letters. Other developments in shareholder proposals relate to policies from proxy advisory firms. Glass Lewis published a written policy in its 2020 rules update that if a company decides to exclude a proposal without the affirmative concurring decision of the SEC staff, Glass Lewis will recommend against the election of each director that is a member of the governance committee. ISS hasn't yet taken a position on how it will handle situations where the SEC doesn't confirm exclusion of our shareholder proposal. They appear to be waiting for more information from the SEC or a real example of the SEC declining to state of view on a shareholder proposal before the ISS issues any formal policy guidance for the 2020 season. I hope that information is helpful, and I'll turn it back to you, Janie.
Thank you, Lisa. Our next presenter will be Jill Webb. Jill is Senior Counsel in the Securities and Capital Markets Group and located in our Richmond office. And she and I have had many years of presenting on these topics. Today, she is going to be talking to us about the SEC's proposed new rules relating to proxy advisory firms. Jill?
Thank you, Janie. So last year at this actual exact same SEC webinar, we presented, and I presented on the initiatives coming out of the SEC's proxy roundtable, which occurred last November in 2018. And I'm pleased today that we get to update a couple of the things that were discussed in that proxy roundtable, one which was just presented on about the SEC's, the shareholder proposal rules, and the second is a rule that was proposed on the same day, which I'm going to be covering here in this presentation. We are finally seeing some rulemaking coming out of that SEC's proxy roundtable from November 2018. The one that I'm going to present on today was the second one that was issued on November 5th, and it is called Amendments to Exemptions from Proxy Rules for Proxy Voting Advice. Both of the proposals, which Lisa and I have presented on today, were decided by 3-2 votes with the SEC Commission, and those were decided along political lines, Republicans with 3 and the 2 Democratic votes objected. The proposals, the rule proposals combined were 320 pages in length, and there were 345 individual questions for comment. So I'm just setting that up so we have some context in which to discuss these proposed rules, because indeed they are not final rules, they're just proposals. Comments are due on the rule that I'm talking about as well as Lisa's rule. They're both due right now on February 3rd, 2020, although there has been a proposal or a comment requesting that there be a 120-day period from the publication date versus the 60-day period, which is currently in place. And the publication date in the Federal Register was indeed on December 4th, 2019. So, proxy advisory firms. I'm using an acronym here, which is PAF. So you'll see it throughout the slides as PAF. The advent of PAFs, or the popularity, at least, the growing popularity of PAFs, really started in 1970. Catch up that slide. Whoops, I passed it now. In 1974, with an ERISA law, which required pension plans to vote responsibly. Prior to that, of course, U.S. public companies were submitting matters to shareholder votes for many decisions every year, but those votes were often not taken seriously. Once the 1974 ERISA law came out requiring pension plans to vote responsibly, you had pension plans and other institutional investors needing advice on how to sift through numerous proposals on their portfolio company matters. And the SEC has the requirement that investment funds also vote their proxies. So the need for both researching and actually getting the vote out was ripe for outsourcing, and that happened right after 1974. And now we have ISS and Glass Lewis, who are the two preeminent proxy advisory firms controlling more than 97% of the proxy advisory market. And there's a statistic in there that 37% of shareholder votes, which in 2019, the statistics there, were controlled by those two proxy advisory firms. In fact, the chairman of the SEC, Jay Clayton, compares proxy advisory firms, he calls them significant third-party market participants, such as auditors, rating agencies, and research analysts. And everyone who's in the corporate practice of law knows that rating agencies, research analysts, those sway votes or sway outcomes tremendously, and we're now seeing proxy advisory firms having that same type of import with swaying votes. Information overload to shareholders has brought about a new concept, robo-voting, a new word, or a word that's really gained popularity in the last 18 months or so, which people believe is happening when asset managers are voting the proxies automatically without any independent evaluation, and they're relying entirely on proxy advisory firm recommendations. So there has been a growing consensus that there's a need for information material to investment decisions for those making the investment decisions, and proxy advisory firms do seem to control that flow of information for many, many shareholders. We'll flip to the next slide. This slide sets out how the SEC's focus has really been heightened from 2018 through 2019. I just set out here some of the events that happened in the last year or 18 months, where we saw that, and again, we presented on some of this last year. We ended last year with the 11-18, where the SEC had a roundtable with the stated goal of getting more information from Main Street investors to and from Main Street investors. And the roundtable happened last November, and we are now seeing in August of 2019, this past recent August, the SEC issued interpretive guidance similar to the rule we're going to talk about now, but it was just interpretive guidance under the existing rules relating to proxy advisory firms. And now we are seeing new proposed rules come out. And on October 31st, 2019, we saw the ISS, the large proxy advisory firm, sued the SEC in federal court on that August 2019 interpretive release, suggesting that proxy advisory firm voting advice was a proxy solicitation. And we set out in this slide what the ISS is claiming and contending. That matter is still ripe in federal court. There's been no decision on that. And these are the same issues that we're going to be talking about with the proposed rules. At that time, ISS was suing over interpretation, but it is the same material that's being discussed here. So these new rules will obviously be affected by the outcome of that litigation. Okay, to the actual nuts and bolts of the November 5th proposed amendments. There are three major things that came out of the November 5th proposed amendments. The first one is that move the slide. The proposed rule amendment codifies the SEC's interpretation that proxy voting advice generally constitutes a solicitation. So that would be an amendment to Rule 14A1, Paren 1. So that rule would be that interpretation would be codified. The second large thing that is done by the proposed rules is it conditions the availability of the exemption from proxy information and filing requirements for a proxy advisory firm's recommendation on compliance with several procedural requirements. And we'll go through each of those. The first one is additional disclosure requirements regarding material conflicts of interest. That would be a revision of Rule 14A2B. And the second dash under the second bullet in the slides are new procedural requirements for review and feedback periods, as well as a hyperlink to the company's views in the proxy advisory firm's recommendations. The third large thing coming out of those proposed amendments are new clarification on the anti-fraud rules and how those apply to the proxy advisory firm's recommendation. And that's a very important component of it for those of you who have had to spend time trying to correct a proxy advisory firm's recommendation either for or against your proposal. Factual corrections now will hopefully come easier because they are specifically linked to the anti-fraud provisions. Okay, so let's go through the three new requirements for the exemption. for a proxy advisory firm to be able to rely on the exemption from the information and filing requirements, there has to be three things that happen: prominent disclosure of material interests, mandatory interaction during the review and feedback periods, and an active hyperlink leading to the company or the other soliciting person's statement. First, prominent disclosure of material interests. That is going to need to be included in the proxy advisory firm's voting advice, as well as any electronic medium used to deliver that advice. They must disclose, the proxy advisory firms must disclose any information material to assessing the objectivity of the proxy voting advice, and they also must disclose any policies and procedures used to identify the material conflicts of interest and steps taken to address. The proposed rules specifically say that disclosure must be sufficiently detailed and that boilerplate is insufficient, but this is a matter that really lends itself to over boilerplating it, and so it'll be very important to see how individual these disclosures end up being, or if we're going to see a lengthy paragraph just embedded in proxy advisory firms' recommendations trying to state what its policies and procedures are and not really making them particular to the company of which they are discussing. The second thing is the mandatory interaction during the review and feedback period. This is a real shift. As you might know, and which I think we hint at later on, some proxy advisory firms do allow a very short period of feedback if you ask, and particularly if you pay as a company for that proxy advice before it's published. Now there is going to be this formal review and feedback period. In this chart, we go ahead and set, and the review and feedback period is tied to how far in advance of the shareholder meeting the company or the other soliciting person has filed its definitive proxy material. And the longest that review and feedback period is 5 business days, which is not a long period to actually be able to achieve feedback. The review obviously will happen very quickly and expeditiously. That's completely in the company's control as soon as it receives the advice, but it is the feedback period that I think there's been a lot of discussion about whether you will actually be able to engage in feedback with these proxy advisory firms. And in this next slide, you see we talk about what the current practice is. Oh, wait, I'm sorry, I'm getting ahead of myself. The proxy advisory firm must provide final notice of the voting advice as well, and that has to happen no later than 2 business days prior to the delivery of the advice. Proxy advisory firm is not required to incorporate or reflect any of the feedback it receives on its recommendations, but remember what we spoke about earlier with the anti-fraud rules. If companies are in a position that they are able to prove factual inaccuracies, the proxy advisory firm should be more willing to take those changes than they've been in the past because the anti-fraud rules clearly apply. And we note here that a proxy advisory firm can require the company to enter into a confidentiality agreement to have that review and feedback period. Third is the active hyperlink leading to the company or other soliciting person's statement. The proxy advisory firm has to include that. And the active hyperlink is a way for the company to actually have its response, the company's response, embedded in the proxy advisor's report. But please note that the company or the other soliciting person, if that's who's using this, will need to file its statement with the SEC as soliciting material. The key to this hyperlink, though, is that it goes with the proxy advisory firm's recommendation. And so if you're sending this to an institutional advisor and there is or an institutional investor, and we're running into the danger of robo-voting, which we talked about earlier, you do have the company's response right there embedded in that hyperlink. So if the proposed rules were made final exactly as written, what is realistically going to change? And I have in the slide that the current practice would change because we have very little review in the current rules. Again, ISS provides certain companies, S&P 500 companies, 48 hours or less. Glass Lewis charges a fee for the preview of the report. Both of those would change. Factual error correction we've talked about. We do believe there'll be an impact on pricing for the 2 large proxy advisory firms. not going to get less expensive. It's probably going to get more expensive because it's going to require more work on their part. I've seen some suggestions that there might be an opening for competitive dynamics for new proxy advisory firms. Not sure if I'd hold my breath on that. Those two seem to have control of the market. Timing, again, is 60 days from publication, so right now, February 3rd, 2020, and there are a handful of responses on the proposed rules, which make for interesting reading. What's next, and this is what I'm wrapping up with, the consensus is that these are probably the outer limit as to what the current commission will do to curtail proxy advisory firms' substantial influence. These are only going to be curbed back in the comment period. They're not going to be made more aggressive. And obviously the prospects for final adoption could be impacted by a whole host of things, including the political calendar and the upcoming election. These rules were perceived favorably by companies and some other market participants, and while there was opposition and criticism from proxy advisory firms and some shareholder groups, it was not overwhelming objections, probably because they really won't move the needle so much. And I think that wraps it up, Janie. If any questions, obviously we're happy to answer them.
Thanks, Jill, for those insights. It's a very interesting development, and we'll be watching to see how those proposals, yours and the ones Lisa discussed, move through the system. It pretty much seems like we're talking about an actual impact at the earliest in the 2021 annual meeting season, because I don't think we'll get them through in time for 2020. But let's turn to our next presenter. This is Maria Sasanowski, who is in our Pittsburgh office. She's a Securities and Capital Markets Associate and focuses her practice on corporate law, including securities compliance, corporate finance, capital markets, and mergers and acquisitions. And she's going to be talking about those proxy advisory firms, Glass Lewis and ISS, and the voting guidelines that they'll be using in 2020. Maria?
Thanks, Janie. Let me just get my slides queued up here. Okay. So I'll be speaking with you today, as Janie said, about the recent updates to voting guidelines published by ISS and Glass Lewis, which they have each adopted in anticipation of the upcoming 2020 proxy season. In addition, we'll talk briefly about topics and trends in board diversity and what developments in that area boards can expect to see over the coming year. We'll start with Glass Lewis. So Glass Lewis focused its 2020 updates on a few key areas. As you heard from Lisa and Jill, Glass Lewis revised its voting guidance related to shareholder proposals in light of recent SEC guidance on this topic. Additionally, and what I'll be speaking about with you today, Glass Lewis updated, or in some cases clarified or codified, its voting guidelines on key committee performance and disclosure, which reaches the Audit Committee, the Corporate Governance Committee, and the Compensation Committee, exclusive forum provisions, supermajority vote provisions, and gender pay equity. So let's take a look at what Glass Lewis's voting guidelines are for these. We'll start with key committee performance and disclosure. Glass Lewis will generally recommend voting against an audit committee chair if fees paid to a company's external auditor are not disclosed. Glass Lewis couches this as a codification of its existing guidelines rather than a policy update. With respect to the Corporate Governance Committee, Glass Lewis's policy updates reflect concerns over a director's attendance at board and his or her applicable committee meetings. Glass Lewis will vote against a Corporate Governance Committee chair in two cases. First, for failing to disclose altogether director attendance at board and committee meetings. Or secondly, disclosing attendance that indicates a director failed to attend at least 75% of those meetings, but making the disclosure so vague that it shields the identity of the specific director who missed the meetings. Separately, Glass Lewis provided updated voting guidelines for the Compensation Committee, which I'll leave to Will to touch on in his presentation. With regard to exclusive forum provisions, when a company has adopted such a provision, if the provision is, quote, narrowly crafted to suit the unique circumstances of the company, Glass Lewis may not recommend a vote against the Governance Committee. On supermajority voting provisions, Glass Lewis is taking an approach that's intended to protect minority shareholders. It's therefore recommending shareholders vote against shareholder proposals that are submitted to controlled companies and request eliminating supermajority voting standards. With regard to gender pay equity, Glass Lewis is taking an approach similar to that of ISS, in that it is reviewing on a case-by-case basis any shareholder proposal that a company disclose its median gender pay ratio. If a company can show that it's provided sufficient information concerning its diversity initiatives, as well as an explanation of steps taken to ensure that women and men receive equal pay for equal work, then Glass Lewis will generally recommend against shareholder proposals seeking more disclosure on those topics. Glass Lewis's updated guidelines will be effective for all meetings held on or after January 1st, 2020. Now let's turn to ISS's 2020 policy updates. ISS's updates focused on the areas of board composition, board accountability, shareholder proposals for an independent board chair, share repurchase programs, and, like Glass Lewis, the gender pay gap. Of note for ISS this year is that ISS has completed a one-year transition period for implementation of its U.S. gender diversity policy. With regard to board gender diversity, ISS has said that absent a firm commitment to achieve gender diversity within a year, ISS will recommend against the chair of the nominating committee or other directors as appropriate if the board lacks a female director. A firm commitment from a board with no women on it previously will only be a mitigating factor for 2020, but will not extend beyond that period. Companies that previously had a woman on the board but now do not must first acknowledge a current lack of gender diversity and secondly provide a firm commitment to re-achieve that status in the following year. ISS defines a firm commitment as a plan with measurable goals outlining the way in which the board will achieve gender diversity. I'd like to just pause here for a moment to touch on the topic of board gender diversity and give you some trends that are occurring in this area. 2019 heralded the year where the S&P 500 no longer had any company with an exclusively male board. ISS reports that as of July 15, 2019, however, there were still 329 companies in the Russell 3000 index with no women on their boards. Therefore, based on these updated 2020 guidelines from ISS, absent a firm commitment from those companies to add a woman to their board within the next year, it's likely that ISS would withhold a vote supporting the nominating committee chair or the responsible directors of those companies in the upcoming 2020 proxy season. That said, ISS further reports that 45% of new board positions among the Russell 3000 were filled by women in 2019, which is up from 34% in 2018. Landscape shifts such as these have been attributed to the efforts of large asset managers to promote these mandates both within their own companies and the companies that comprise their portfolios. Expect the next stage of this development to show an increased focus and a push for gender parity on boards rather than minimal representation. In the coming years, boards will be increasingly asked by the company's shareholders to prioritize diversity, set meaningful targets to achieve full gender diversity, expand their recruiting pipelines, and promote board refreshment by increasing board size and adopting term limits or age limits. We will keep you apprised of further developments in this area. I'd like to turn now to ISS's policy updates for newly public companies. These updates apply not only to companies that have recently IPO'd, but also companies that are newly public due to recently emerging from bankruptcy, having been spun off, or direct listings. For these companies, ISS issued guidelines against A, supermajority vote requirements, B, classified board structures, or C, other, quote, egregious provisions, or alternatively, companies who have a multi-class capital structure where those classes have unequal voting rights. In each of those cases, ISS would consider a reasonable time-based sunset of the provision, that is, a sunset lasting not longer than 7 years, as a mitigating factor in deciding whether to recommend a vote against the director or the board. Touching briefly on restrictions on shareholders' rights, ISS supports granting shareholders an unfettered ability to amend the bylaws, or, in the alternative, providing a proposal to shareholders that would grant them such an unfettered right. ISS will oppose management proposals that seek to approve or ratify requirements that are in excess of SEC Rule 14a-8's requirements regarding submission of binding bylaw amendments. With regard to shareholder proposals on an independent board chair, ISS will generally vote for shareholder proposals requiring that the board chair be filled by an independent director. And this year has now enumerated 6 factors that will give substantial weight in its likelihood of giving a for recommendation. This is a vote for an independent board chair. Those factors are: 1, a majority of non-independent board and or the presence of non-independent directors on key board committees. 2, a weak or poorly defined lead independent director role. 3, the presence of an executive or non-independent chair in addition to the CEO, a recent recombination of the role of CEO and chair, and or a departure from a structure with an independent chair. 4, evidence that the board has failed to oversee and address material risks facing the company. 5, material governance failures or evidence that the board has materially diminished shareholder rights. And finally, number 6, evidence that the board has failed to intervene when management's interests are contrary to shareholders' interests. With regard to share repurchases, ISS has updated its policies to show it will generally support buybacks, except in certain situations, including 1, the use of targeted share buybacks as green mail or to reward company insiders, 2, the use of buybacks to boost earnings per share in an attempt to increase executive or other insider payouts, and also 3, repurchases that would threaten a company's long-term viability or, in the case of a bank, its capitalization level. Lastly, ISS has updated its policy on gender diversity and pay gap data to also include a policy for a case-by-case review of shareholder requests for pay data by race or ethnicity in addition to gender. And ISS has also clarified its director attendance guidelines to denote that its policy only applies to directors who have served in a complete fiscal year on the board. ISS's updated guidelines will be effective for all meetings held on or after February 1st, 2020. And that concludes the overview of the Glass Lewis and ISS policy changes. Thank you for your time.
Thank you, Maria. Very interesting, particularly in light of Jill's presentation on the influence of the proxy advisory firms. Next up, we have Taylor French and Will Tice. Taylor and Will are partners in our Tax and Employee Benefits Group and are located in Charlotte and Washington, D.C., respectively. These two gentlemen co-chair our Employee Benefits and Exec Comp Group, and today they're going to be discussing executive compensation disclosures for 2020. So Taylor and Will, I'll turn the mic over to you.
Great. Thank you so much, Janie, and good afternoon, everyone. We're going to be talking about the new hedging disclosure policies that will be effective for most folks starting with the 2020 proxy. And then I'm going to turn it over to Will, who's going to address some executive compensation matters from our good friends at the proxy advisory firms. So to kick it off on the hedging disclosure policies, the first slide here is really just by way of background, a historical play-by-play as to when Section 955 of the Dodd-Frank Act was passed that included these original rules regarding disclosures of hedging of equity securities back in 2010. And as we all likely know, the market has pretty much moved past what the regulatory regime has been in these 9 years since then. But last year, the SEC got around to finalizing the hedging disclosure rules, And so while we all, probably most of us, have already been adopting hedging policies and making disclosures about said policies, now that we have final rules, let's talk about how to comply with them. First and foremost, the new rules say that we have to disclose in our proxy statement or any other information statement where directors are elected, whether or not employees, officers, or directors are permitted to engage or are prohibited from engaging in hedging transactions with regard to covered equity securities. And so what exactly do we have to do? We have to provide some sort of summary regarding our policies or practices, or if you'd like to not include a summary, you can just go ahead and disclose the entire policy. My hunch is that most people are going to opt for the summary. Helpfully, the SEC has said if you happen to not have a hedging disclosure, a hedging policy, then you can comply with the new rules by disclosing that you have no such hedging prohibitions, or you're allowed to affirmatively state that you allow all of your employees, officers, directors, et cetera, to engage in hedging activities. We have a sneaky suspicion that neither of those two options are going to be particularly attractive, and frankly, as I mentioned earlier, most companies have already adopted anti-hedging policies. The last thing that's on this slide, I think, is an important note, is that there is actually no disclosure requirement with respect to actual hedging transactions. And the actual hedging transactions would be, we don't actually have to disclose something as to, well, someone engaged in a hedging transaction in violation of our policy. Now, that might occur elsewhere under Section 16 rules, but not pursuant to the Dodd-Frank rules. So let's talk about the hedging disclosure rules and some explanations of some of these defined terms. It looks like the slides are moving around quite a bit. Let me try and get back to the right spot. Maybe somebody can help me get to the right spot. But as we do that,
on the contact information slide for Maria.
Okay. Well, I'll keep going with respect to hedging activities. The final rules take a very broad and principles-based approach to defining what hedging activities might include. They give a list, but it's an including but not limited to list. They talk about basically any purchase of any financial instrument that protects against downside risk. One of my favorite being the prepaid variable forward swap contract, which I don't totally understand what it is, but it sounds amazing. The interesting thing here, and a little bit of commentary as we've been working with our clients, is think about your policies, because a lot of folks have hedging policies, anti-hedging policies, and then we also have anti-pledging policies. Now, pledging would be like taking shares of stock that you might own and using those as collateral for a mortgage. That type of transaction that pledging transaction does not necessarily provide the executive against any downside risk, and so may not be covered by these rules. So really think closely about what actually is required to be in this disclosure versus what's not required to. Now, all that said, market practice, especially for the executive compensation disclosures, have been that most clients are disclosing the fact that we prohibit executives from hedging and we prohibit executives from pledging their securities. The term covered securities used by these final rules, likewise, is very broad. For a lot of clients, it's going to be pretty easy. It's going to be the class of securities that are publicly traded. But as you can see, if you have publicly traded subsidiaries, folks in the energy industry with MLPs, the disclosure could cover those subsidiary entities as well. And lastly, on this slide, the coverage of to whom the disclosure applies is, again, keeping with the theme, very broad. All employees, including officers and directors. So that means if we have a hedging policy that says we prohibit all employees throughout our organization from purchasing hedging products with respect to our securities, well, then that's what the disclosure should look like. Now, if your hedging policy might be a little bit narrower than that and only apply to hedging transactions by executive officers, you'd want to specify that classification in your actual disclosure. And a little bit of commentary there is, when we've been working with our clients, is that you may want to consider the scope of your hedging policy, because while a lot of folks may have, the initial reaction is, oh, well, a broad hedging policy is good, right? We prohibit everyone from hedging our securities. Well, for an organization that grants equity to a broad, range of employees, there really is sort of a question of, well, how do you police that policy? If you've got a more second, third, fourth tier level employee within the organization that happens to own some of your company stock and goes out and buys a, prepaid variable forward swap contract, are you ever going to know? And the answer is probably not. So that is leading some folks to consider tightening the scope of their hedging policies to ones that they can actually monitor and enforce. Finally, we got the slides back. So let's talk about the effective dates of this. Again, for most folks, it's going to be starting with the 2020 proxy season. As you can tell, for the smaller reporters, we have a little bit more time. Again, whenever directors are elected, we need to provide this disclosure. So most of the time it's going to be our annual meetings, but it could be special meetings as well. And then this is an interesting aspect of the rules is, well, these new rules come under item 407, not 402. And 402 is the CD&A rules. So as a technical matter, we don't have to put this anti-hedging disclosure statement in the CD&A. Now, you can do cross-references if you don't want to put it in the CD&A, and there might be some good reasons why you don't want it in the CD&A. Again, this is something that is, covers a broad range of folks, not just your executive officers or your named executive officers. So you might want to have it someplace else. I've been hearing anecdotally that this may be similar to the much-discussed pay ratio disclosures, where folks are going to take the approach of short, sweet, and in the back. Finally, just a couple tips and ideas of what to be thinking about. Most folks at this point are gearing up for proxy season or are knee-deep in it, as is in my case. But it's time to start, thinking about what our hedging disclosures are going to look like. And this is, I think, a key point, is consider after you draft what your disclosures look like, that may have an impact going through that exercise as to, do we want to make any adjustments to our anti-hedging policies, as we kind of dig into the nitty-gritty and we actually have to think about complying with these technical disclosure rules. This might be a good time to go through that exercise as well before 2020 proxies come out. And so with that, I'll turn it over to Will.
Great. Thanks, Taylor, so much. Just wanted to shift gears here and just spend just a minute or two talking about the latest policy updates from our friends at ISS and Glass Lewis for 2020. There's really, on this first slide, there's really only one big point. This is the ISS update that I wanted to hit here on this slide. I think the first two, while interesting, are only going to have some limited practical impact. But the third bullet, I think, is worth mentioning. It relates to non-employee director pay. ISS has been warning us for several years that they're going to begin recommending against directors if there is a quote-unquote recurring practice of companies' director compensation being excessive. 2020 is going to be the first year that such recommendations will be made. You can see on the slide here the various mitigating factors and problematic practices that ISS is going to look at in this context. I think the important takeaway here is for everyone to take a closer look, if you haven't already, at your director compensation disclosure, which sometimes gets overlooked, in the CD&A review, et cetera. But take a closer look at your director comp this year and in future years to make sure that you're being appropriately responsive to this concern. And then, the next slide, Glass Lewis. In the interest of time, I'm not going to go over the Glass Lewis changes in detail. You can see the main changes described here on the slide. Of course, if there are any questions on these or on any of the matters that Taylor and I have discussed today, feel free to reach out to either one of us. Thanks, everyone. And Janie, I'll shoot it back to you.
All right, thank you, Will. And I am going to advance our slides up to Lisa Taylor again, who's going to speak with us about ESG, environmental, social, and governance matters. And if you, by the way, are having any difficulty in the audience with the advancing of the slides, we have had the suggestion that we ask you to refresh your browser, and that should take care of it. So, Lisa, I am turning the mic back to you.
Great, thanks, Janie. As Janie noted, ESG is an acronym for environmental, social, and governance considerations. There's sort of two somewhat overlapping approaches to ESG. First, there's the idea of corporate social responsibility, which incorporates sustainable development into a company's business model. And then there is the ESG long-term profitability focus of many investors. At its core, this focus refers to the risks and opportunities that could impact a company's ability to create value over the long term, and how the company is managing these risks and taking advantage of these opportunities to ensure its long-term stability. Figuring out how to address these ESG issues is one of the most prominent governance and disclosure issues the companies face today. So these are some of the factors that are affecting why companies are facing ESG reporting issues. Again, in 2019, we had the third consecutive year in which environmental and social-related shareholder proposals accounted for the majority of them. Many of these proposals called for transparency and action on ESG matters. So by doing this kind of reporting themselves, companies can head off shareholder proposals that might be more challenging to meet. Another factor is that many more investors are really interested in sustainability criteria for their investments. A GRI study shows that over $30 trillion is invested using sustainability criteria, and this has grown by over 25% in the past 2 years. Also, millennials, which are people born between 1980 and 1996, are focused on ESG issues. In particular, a Deloitte study found that 67% of millennials believe that investments are a way to express their social, political, and environmental value, versus only 36% of baby boomers. Also, major investors like BlackRock and Vanguard are expecting reporting on ESG risks. As early as 2016, BlackRock put out a white paper characterizing ESG information as integral to investment stewardship. Also, ISS and Glass Lewis have ESG ratings. And 86% of S&P 500 companies provide sustainability reports, though we'll discuss later its reporting is less prevalent among small and mid-cap companies. Well, there are a lot of ESG reporting frameworks out there. GRI is the Global Reporting Initiative, is the oldest of the frameworks. Then we have the Sustainability Accounting Standards Board, which has published a set of standards for 77 industries, customized by industry. Another important one is the United Nations Global Compact, which it was launched in 2000. It has over 7,000 corporate signatories in 35 countries. The Task Force on Climate-Related Financial Disclosures focuses on financial risks of climate change, and it's become pretty prevalent with energy and companies. And lastly, this Edison Electric Institute and American Gas Association standards focus more for energy companies. NASDAQ has also published a guide on ESG reporting. It first published it in May 2017, and it updated it recently in May 2019. There's no required disclosure of ESG data by NASDAQ, and it's just publishing this guide to be helpful to listed companies. And it's tried to organize principles and metrics under the acronyms environmental, social, and governance. And you can see in the chart a diagram of the issues that they provide guidance around. Moody's is another organization that's evaluating ESG disclosures. Credit rating agencies are considering these issues and evaluating creditworthiness of companies they rate and are seeking better information to use in their decision making. So Moody's had done a study of looking at the quality and level of disclosures that companies are providing, and that's what's summarized in the chart. Even the Chamber of Commerce is getting in on the ESG action. In October, the Chamber initiated a project for growth and opportunity, which includes voluntary ESG reporting as one of its initiatives. And following on that, in November 2019, this Project Go released a best practices guide for companies to use in ESG reporting. And this is for public and closely held companies, private companies. And just to highlight some of the concepts that they promoted in this best practices guide, the concept that a company should focus on the risks and opportunities that actually affect their long-term value. They said companies should tailor their disclosure for the intended recipients of the report. In the concept of owning ESG reporting, companies should develop appropriate internal teams and reporting metrics for their particular company. They should use plain English, make their ESG disclosures readily accessible on their website or in other places where they're easy to find. They should maintain flexibility and explain the rationale. This means decide which metrics and topics are actually relevant to your company and explain why in your reporting. And lastly, describe the internal review and audit process you might use for ESG-related information. Delaware in 2018 adopted this concept of a certificate of adoption of transparency and sustainability standards. That company can obtain this certificate if they file a standard statement with the Delaware Secretary of State containing certain information, and they make available a public report annually about their initiatives on sustainability matters. So let's loop back to some of the reporting obligations under the SEC. As succinctly summarized by Chairman Clayton, if a matter, whether it's considered ESG or not, is going to affect a company's bottom line or presents a significant risk, then boards should be doing something about it, and if it's material, they should disclose it. Similarly, SEC CorpFin Director Heinemann recently noted that companies should consider disclosure on all emerging issues that affect long-term sustainability. Just as a quick reminder, back in 2010, the SEC issued climate change guidance and noted that that kind of disclosure could be called for in the description of the business, legal proceedings, risk factors, and MD&A, and it noted other triggers that could require reporting. Also, in August, the SEC issued proposed rules to modernize the disclosure requirements under SK, and under the Item 101, description of the business, they have a new disclosure topic regarding any human capital measures and objectives that management focuses on in managing the business. So that's a sort of typical ESG type measure that would be required now. So that's a quick refresher on the SEC requirements and recent developments. Let's turn to a quick study on giving what companies are doing in ESG reporting. Argyle looked at the Dow 30, and you can see here that it's very prevalent among very large companies. 60% are including some sustainability metrics in their proxy, 67% are discussing board oversight. But it's less prevalent among smaller companies. This is based on a law firm survey of 84 companies. It starts at 36% between 3 to 7 billion, and it drops to a quarter for companies under $1 billion. We find that sustainability disclosures are very prevalent among energy companies, but less prevalent, probably least prevalent among life sciences companies. Of course, controlled companies and dual-class companies are less likely to report on it, and older companies are more likely. Because we're going to run behind, I'm going to kind of go forward. There's some additional guidance on what companies are doing and how they're seeing and thinking about ESG and predominant activities. I guess just a couple of points to highlight. As I noted, larger companies seem to be doing more and reporting more on this, and it is something that they face from investors more often than smaller companies. But companies nevertheless are having to talk about their governance issues related to ESG matters, maybe less prevalently having to discuss environmental issues. And among investors, fund managers are more likely to be involved with ESG reporting and find that to be important than sell-side or buy-side analysts. All right, so just to recap some tips. If you're starting to do some sustainability reporting and focusing on it with your company, here's some tips to keep in mind. First, focus on the risks and topics that are material and impactful for your company. Assemble the right teams, include HR, operations, finance, legal, and senior management. It's really important to have senior management trained and educated about these issues and the board and obtain their support to any sustainability initiative. Select a well-known reporting framework to begin. Engage investors and others interested in the report to understand their interests and goals. Gather information on your existing efforts and develop goals and timelines over a period of years. You know, sustainability is really a journey. It's a big task and a lot of work, so it's a journey, not a race. But lastly, remember there are legal risks involved in sustainability disclosures. The sustainability information you put on your website or in any other thing should be subject to the same disclosure and internal controls processes to assure that the information and the numbers are complete, accurate, and that there are processes for its review that are in place. This review should include the language, the narrative, the text, the numbers, and the metrics. We understand that a McKinsey survey released in early 2000 found that investors think that sustainability reports should be audited, so maybe that would be coming down the pike. And keep in mind that the SEC compares disclosures between information filed with the SEC and information on the website. So thanks for your time. ESG issues and reporting will continue to be a developing issue for lawyers, and we hope this information was useful as you continue considering ESG matters.
Thank you, Lisa. And I will say McGuireWoods has a long history of interest in these issues. I remember actually doing some studies with our associates of discrepancies between reports that were beginning to appear on websites and the absence of information in SEC reporting. So we will continue to monitor this area, and thank you for that presentation. Our last presentation will be by Ann Team Kelly. Ann is counsel in our Securities and Capital Markets group and located in our Charlotte office. She focuses her practice on representing public companies in corporate finance transactions, securities law compliance, mergers and acquisitions, and corporate governance. And she's going to discuss updates on 10K, 10Q, and 8K reports for 2020. And one other item I'll throw in with that is that we will shortly have our D&O questionnaires available for those of you who are interested in seeing how those have changed from last year, which, spoiler alert, not very much. Ann, take it away.
Thanks, Janie, and I will be very brief. There's not much new to discuss as to what impacts on 10Ks, 8Ks, and 10Qs are for next year. Most of the line item disclosure changes are in the FAST Act modernization and simplification of Reg SK, adopted by the SEC. That became effective April, May, and we went through this pretty extensively in our September webcast, so I refer folks back to that. But just a couple of things I did want to highlight specifically for the 10K for calendar year end, or companies that have fiscal years that coincide with calendar year end. MD&A, one of the significant changes is that now you are no longer going to be required to discuss the earliest of the 3 years of the financial statements in your MD&A, as long as you have discussed it in a prior report. And if you determine not to discuss that, you have to make a cross-reference in your current 10K to that prior report where that disclosure is contained. As a practical matter, I am not sure that we expect to see a lot of changes here, given historically the emphasis that has been placed on MD&A and disclosure, and it's fairly simple to keep that disclosure in there, but that is an opportunity for change. The description of property in a 10K, that has been clarified. That requirement there has been clarified, that you really only need to focus on the material properties. Again, I think many registrants have already focused on material properties, as that was the intention, but this could be an area where you could perhaps cut back on your disclosure in your 10K. Identification of material contracts. Here, I would just say, look through your material contracts on your 10K again and see if there are any that can roll off, as you are no longer required to look back 2 years. In other words, the standard is only a contract that is material and that is either to be performed in whole or in part after the filing of that report. So you don't have to specifically look back 2 years. Going to flip a little bit. I'm not going through my slides because it's not working correctly, plus I'm going very fast. New item 601B4, 6. This is something I think that is slipping by a lot of registrants, or slipping up on a lot of registrants. This requires a company to now include as an exhibit to the Form 10K a description of its securities similar to that which is in a registration statement, like if you're describing your common stock, if you're offering that, or your preferred stock, or your debt. For a company that has a lot of different classes of registered securities, like multiple series of debt or multiple series of preferred stock, this could be quite an undertaking. The SEC will allow you to incorporate by reference, but only in future years. This first year, the 10K needs to include a separate exhibit that contains these descriptions of the listed or registered securities. So that could involve quite a bit of work to put together for certain issuers. In the future, as long as nothing's changed from the prior year filed exhibit, you can incorporate by reference to that prior filed exhibit. Flipping on to let me back up a minute here. Another source of information to keep in mind when you're preparing your reports for future years or the next year is SEC and staff guidance. The SEC staff issued a new statement on LIBOR transition in July of this year, and it's a multi-division statement, and Corp Fin is also included in that. And in that statement, the Corp Fin considerations are consider your risk factor disclosures about LIBOR transition, disclosures in your MD&A, board risk oversight, and in your financial statements. I think the thing to take away is that the commission and the staff are taking this seriously and believe that for a number of issuers, this could have a very material impact on them, and that these issuers need to be talking about that now and preparing their disclosures accordingly. There are a couple of older pieces of guidance that are still relevant, not from this year. I'm flipping over to my last section is talking about staff comments on filings, and this is the last source I was going to mention of source of information to consider when you are preparing your filings. I've listed here about 10 or 11 of the most frequently mentioned staff comments in the past year, year and a half or so. None of these should come as a surprise. Non-GAAP financial measures is still up there. One thing to point out there, in addition to the historic comments that the staff has been making, they are moving more towards making comments about more substantive issues, such as whether a company is targeting individually tailored accounting principles, and they will require you to discuss that with them and justify that. So that's one thing to keep in mind. Revenue recognition, that's another big area, not surprisingly, given that this past year has been the first time that companies have been required to implement this ASC, so that's another one. And your MD&A, as usual, the typical areas of staff comment: material trends and uncertainties, critical accounting policies, liquidity and capital resources, contractual obligations, and I will let you review the list in there of some of the other areas that are more common. And Janie, I will stop now since we are so far over.
Well, Ann, thank you. And your slides are very useful, so I'll remind everybody that these slides and the entire presentation will be archived on our website. I'd like to thank all of the presenters, and if we did not address questions that you submitted during the call, we'll be happy to follow up with you by email, and you can also submit questions by email following the presentation. On behalf of all the presenters and all of us at McGuireWoods, thank you for joining us today, and happy holidays.